Oh, oh, yeah, yeah, yo. Oh, yeah, 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 yeah. Oh, yo, yo. Oh, yo, yo. Oh, yeah, oh, yeah.
This film is dedicated to the memory of traditional Chief Andrew Isaac, Chief Peter John, and to traditional chiefs David Salmon and Franklin Madros. The legends of the Athabascan clans describe the travels of Alaska Native ancestors across the Bering Land Bridge thousands of years ago. Ever since, Alaska Native people have continuously inhabited this land, now known as the State of Alaska. Although there are distinct languages, cultures, and traditions, Alaska Native people share a close connection with the land and waters, and to their traditional values and practices. Since the formation of the United States, tribal justice systems have undergone tremendous assaults and pressures from a variety of fronts. In spite of the turbulent history, tribes continue to develop and operate courts, incorporating traditional values and practices as they proceed. After many years of living with decisions made by federal and state authorities, tribes in Alaska have begun to reassert their jurisdiction, making decisions in the best interest of their people. Ji gwizit din ji naigigin hidai lego venjet gwinzi. Indian law is the body of law that defines the relationship among the federal government, Indian tribes, and the states. Congress has broad legal powers over Indian tribes and may limit tribal authority through legislation. When Congress is silent or unclear, the federal courts may be asked to interpret the intentions of Congress. Court decisions are an important part of federal Indian law that often clarifies the scope and limits of tribal powers. The Indian Civil Rights Act was passed by Congress in 1968 at the height of the civil rights movement in the United States. This act gives rights to people subject to the jurisdiction of Indian tribes.
So in 1968, Congress passed the Indian Civil Rights Act to give the same protections that the Bill of Rights gives to people that are subject to tribal court jurisdiction.
The Indian Civil Rights Act requires tribal courts to give due process to the persons who come before them.
Due means owed or fitting or appropriate. Process means a series of steps leading to an eventual conclusion or outcome. So you put those concepts together, and due process rights are those rights that I am owed as an individual as the court goes through the series of steps that it takes leading to its ultimate decision in the case. I think of due process as having three core elements and four best practices, as I call them. The three core elements would be notice and the opportunity to be heard before a fair and impartial tribunal. The four best practices of due process are keeping a record of the tribal court proceedings, allowing an appeal from the tribal court proceedings, giving an explanation of the decision of the tribal court, and following any rules which the council or the court has set up for itself. And by adhering to those three core elements and by following those four best practices, a tribal court can make sure that it is honoring the due process rights of the individuals who are appearing before it.
Another federal law affecting tribal courts is Public Law 280. This law applies only to a few states, including Alaska. Public Law 280 extends state criminal jurisdiction and some civil jurisdiction into Indian country, but does not take away tribal jurisdiction. Under Public Law 280, the state and the tribes have jurisdiction at the same time, which is referred to as concurrent. Indian country is the legal term to describe the territorial area over which a tribe has jurisdiction, which is the authority to enforce law.
Indian country is quite limited in Alaska because of a 1998 decision by the United States Supreme Court in what was called the Venati tax case. Most of the land in Alaska that is in Native hands was conveyed under the Alaska Native Claims Settlement Act of 1971. Most people are familiar with that. There were village corporations set up and regional corporations set up, and the land that Congress conveyed was conveyed to these regional corporations and village corporations. The case that the United States Supreme Court decided in 1998 held that lands that were conveyed under the 1971 Alaska Native Claims Settlement Act, or ANCSA, are not Indian country because of the way that ANCSA was written. So the vast majority of lands owned by Native groups in Alaska do not meet the definition of Indian country as that has been interpreted by the United States Supreme Court.
Cents to watch the elephant jump.
The Indian Child Welfare Act, also known as ICWA, is a federal law affecting tribal children. Congress passed ICWA in 1978, intending to protect the best interests of Indian children and to promote the stability of Indian tribes and families. Act applies to state courts when they are hearing child protection cases involving Native children, which in Alaska are also called Child in Need of Aid, or CHINA cases.
ICWA requires the states to provide notice to the tribes that the children are in state's custody. It also requires them to provide that notice so that tribes can have an opportunity to intervene in the children's cases and become a party to the case. ICWA also requires the states to place Native children in Native foster homes, pre-adoptive homes, and in adoptive homes when possible.
Congress passed the Violence Against Women Act in 1994, requiring states and tribes to give full faith and credit to protective orders issued by each other's courts. Full faith and credit is mandatory, meaning that the states have to recognize tribal protective orders when the tribe has jurisdiction over the matter and has provided due process.
The central registry system is the way that the state of Alaska keeps track of protective orders that have been issued by state of Alaska, other states, or by tribes. Tribes get their cases, their protective orders, into the central registry system simply by filling out their form, their order, and then turning that into a state court clerk. The clerk then files that into the state central registry system.
While Congress has broad powers over tribes, state governments have a different role. State policies affect the working relationship between state agencies and the tribes. The interests of all people are best served when state and tribal courts work in the spirit of cooperation.
Tribes do not have to apply due process in exactly the same way that state courts provide it. And this is an important strength in some ways of tribal courts, in that as long as a tribal court pays attention to the three core elements and the four best practices, it doesn't matter whether tribal courts do it in exactly the same way that a state court does it. Indeed, in many ways, the fact that tribal members feel more comfortable approaching tribal courts to resolve their disputes is a function of the fact that tribal courts are, in many respects, less formal, easier to use, easier to approach, easier to understand than state court systems are.
Tribal courts are going to be, they always have been an immense help to people in the villages. Recently, with the state of Alaska cutting back a lot of its activities in our villages and throughout the rest of rural Alaska, they're becoming more and more prominent and more important to the way things are done locally. So you've got that role that village tribal courts are now starting to play, fill in gaps that the state is creating because the state is cutting back its presence in villages.
In 1999, the Alaska Supreme Court recognized tribal authority over child custody matters when tribal children are involved. even when Indian country does not exist, through a case called John versus Baker. The state court recognized tribal orders involving children under a principle called comity.
The best word for comity is respect. The idea here is that one court system will recognize and respect the decisions issued by another court system, not because it is mandated to by law, but because both court systems work better if one court system voluntarily recognizes the decisions of another court system.
Most Alaska tribes view their unwritten traditional values and customs as the highest form of tribal law, and have adopted written constitutions and ordinances or codes to complement them.
The tribal community has all the authority of the government, and the tribe itself can delegate its authority as it chooses. If a tribe is going to set up a court with an ordinance as the structure establishing it, probably the wisest and most prudent thing to do is to have a tribal referendum, to have all the members of the tribe be able to vote and express their decision and have show a consistency on the part of the tribe. It gives great legitimacy to the court, and it's useful as a starting point for the future.
The roots of tribal jurisdiction come from the original self-governing authority that tribes had before European settlers came to this land, and are described as inherent sovereignty.
Tribal sovereignty belongs to the entire tribe, to the tribal members. The members then delegate that sovereignty to the council, usually through a constitution. So the tribal council gets their sovereignty from the members. Tribal councils then can delegate some sovereignty jurisdiction to the tribal court for the tribal court to exercise. But the sovereignty lies with the people, the tribal members.
Tribal jurisdiction may be viewed in terms of the territorial area over which a tribe may enforce law, persons over whom the tribe has authority, and subjects the court may handle. Subjects may be divided into civil and criminal.
Most tribes exert jurisdiction over domestic relations primarily, but there are a lot of tribes in Alaska that are beginning to assert jurisdiction over other areas. Alcohol regulation and what we normally think of as law and order type cases are becoming more common.
Alaska tribes are asserting jurisdiction that clearly lays in the area of civil law regarding domestic relations, matters affecting the health and welfare of the tribe, and internal governmental affairs. Some tribal courts are asserting jurisdiction over subjects of a law and order nature in order to protect the health and safety of tribal members. Often more than one government has jurisdiction over a situation, and this shared jurisdiction is called concurrent. When only one government has jurisdiction over a situation, it is called exclusive jurisdiction.
The Alaska tribal courts, by and large, will base their jurisdiction on the fact that at least one of the people who is asking to have the case heard by the court is a member of the tribe, or at least eligible for membership in the tribe. In situations involving child custody, if the children are eligible for membership in the tribe, that would give the tribe enough jurisdiction or authority to be able to decide a case involving parental rights and parental obligations towards that child. If a person who has passed away was a member of the tribe, and the decision is how should that person's property be divided up, the fact that the person was a member of the tribe would give the tribal courts subject matter jurisdiction over that class of cases to decide a dispute between people who are arguing over which one should inherit a particular piece of property. So by and large, Alaska tribal courts look to the question of which of these people are tribal members in deciding whether or not this is a case over which they should exercise their authority.
I see it happening in the village where people are taken to court, like in Fairbanks, and the justice that's given to people is not exactly the same way we do it in the village. We had to live with these people in the village. We can't just bring them in court and send them out the back door. That's not the way we do it in the village. The approach that we have is that we do it, like I said, in a kind-hearted way. We get these people, sit down with them, and give them that justice. And I think it's equal justice because it's native to native, and we're always mindful of what's going to happen to that person, and hopefully that whatever the outcome is, that person will be thinking about what they went through.
Before us, we have a ordinance for a tribal court structure. Would someone like to make a motion to move this forward?
I move that we adopt the tribal court structure ordinance.
Do we have a second?
As the governing body of the tribe, tribal councils are generally responsible for establishing the tribal courts. They have a great deal of flexibility in how they structure their tribal courts. They may be tailored to fit the needs, culture, and unique circumstances of each tribe. In developing a tribal court, there is much potential for enhancing native culture by putting traditional values to practice.
A tribe needs to look to its own history, its own traditions and values to determine what is the most appropriate structure of government for it to live with, how do people feel most comfortable, and also where they want to go with their government.
One of the most fundamental decisions that a tribe has to make when they're establishing a tribal court is whether to separate the tribal court from the tribal council. And this is a difficult decision that tribes have to make, and often the decision is made by the resources that the tribe has available, how big the tribe is. If you come from a small tribe, it may be very difficult to find enough people to fill a tribal council and a tribal court. So you may end up having to use council members as your judges. However, if you come from a larger village where you do have people available, there's a lot of advantages in separating your tribal court from your tribal council. Primarily the idea of separation of powers, and checks and balances, where your tribal court and your tribal council make sure that each other are following the rules.
Tribal courts may have any number of judges, from a single judge to a panel of 3 or more judges. Panels of judges are by far the most common structure among Alaska tribes. When panels of judges are used, there is a pooled wisdom that can be drawn from. The decision-making is spread among several people rather than placed on the shoulders of one person, and the consensus decision-making tends to be more accepted by tribal members. Although there is no law that absolutely requires tribes to have appellate courts, there are vital reasons why tribes establish them.
An appellate court is a court that reviews the proceedings in the tribal court to decide whether the tribal court conformed with due process, whether it followed its own rules, whether it made a mistake that is significant enough that the decision of the tribal court should be set aside or sent back to the tribal court for a new decision, or whether it should be affirmed, upheld. Appellate courts don't do the whole case over again. They don't have to hear all the witnesses, they don't have to follow all the same procedures. They're basically looking over the shoulder of the tribal courts just to make sure that the basics were complied with. Most appellate courts would not overturn a tribal court decision just because the appellate court judge or judges may have made a different decision than the tribal court judge would. Only if the tribal court judge went so far outside the bounds of what the tribal court can and should do that the appellate court feels that it is required that the tribal court decision be set aside, would the appellate court overturn the tribal court or send the case back to the tribal court for more decisions. Just the same as with tribal courts, a tribal appellate court doesn't have to be set up in the same way that a state appellate court is. There are some tribes that will have a single judge do the tribal court hearing and have an appeal that goes up to the full village council, which sits as the appellate court. There are some villages that are experimenting with the idea of having an appellate court that would cover several different villages, so that once the tribal court for a particular village makes a decision, that decision could be appealed to a judge or panel of judges picked by all the villages together. And there are some villages that are setting up a completely separate appellate court for that village in particular, separate from the council and not shared with any other village. So there are various forms of appeals that a tribal court can set up for itself. It's interesting that due process does not require that there be an appeal. That's why I say that I think setting up an appeal is a best practice, but not a core element of due process. However, the Alaska Supreme Court, when it decided the John V. Baker case, was very concerned about whether one of the parties to the tribal court case would have the opportunity to appeal that decision to a tribal appellate court. And so my advice to a tribal court would be that you certainly strengthen your due process by allowing some kind of an appeal from the decision of the tribal court.
I don't know what the consequences we're going to decide to do, but I think everyone needs to keep an eye out for one another and all that. And
the national definition of a youth court is a system where youth sentence their peers. Tribes may follow that definition or expand it to include adults in the decision-making.
In Alaska, in the remote areas, it really is the only system for dealing with juvenile issues, young issues. So it's like an essential program in there to start addressing the juvenile issues in the villages. What happens is juveniles will tend to slip up a little more, slip up a little bit more, until you end up with an escalated problem where you have jail time, state troopers arriving, and so forth. So in remote areas of Alaska, or remote areas of any place in the world, you really need to set up some kind of a juvenile justice system. When you bring the juveniles in themselves to work with you and the people to help make this culturally appropriate, then you can get a system that's designed by the community, they're the stakeholders, and it's appropriate to that community.
Many villages in Alaska are designing tribal youth courts using the circle-style hearings. The circle may be composed of all youth, or a combination of youth and adults.
These are small communities, and as such, small communities are more inclined to exert social pressure upon kids. That's pretty much the only way that it occurs in rural Alaska, is that we don't have no jails, we don't have no courts out there, we don't have no juvenile halls, we have nothing of that sort. So the real power comes from the society, that is the people in those communities, condemning your actions. Tribal Youth Program offers the community that type of pressure, that type of community pressure on individuals, in the hopes that they will see the error of their ways and change in the future. Unfortunately, sometimes it's beneficial, other times it's not. But from my perspective, it certainly is needed, and it certainly is something that communities need to develop and to undertake, because they ain't going to get it nowhere else.
I think Mary and John shouldn't be on a four-wheeler for at least a year or two, because that's at least give them some time to think on what they've done wrong.
Typically, youth courts decide sentences only and do not decide guilt or innocence. If a youth pleads not guilty to a charge, they could be directed to the regular tribal court to hear their case. The regular tribal court could also be used if someone wanted to appeal a sentencing decision of the youth court.
It's definitely important for the continuation of how we resolve disputes in villages to have the youth involved. Doing it through schools, doing it through the Tribal Youth Court Project, getting youth involved through the Tribal Council on tribal court issues on a day-to-day basis, not just as grants may come and go, and really getting them involved from step A all the way through step Z, and making sure they understand all parts of that, not only what's happening on the business side with how a tribal court runs, but also culturally, as they're learning from the elders, how things were done 200-300 years ago, and then how we can apply that historical knowledge to our native society that may have changed since then, but a lot of it has still remained the same as well. with what people are feeling in their minds and their hearts as to how they resolve disputes. So if we are to continue that, we have to get the youth involved. And in order to do that, we have to make sure we get them effectively involved, not just bringing them in and teaching them, but getting them actively involved where they're have an active role in the dispute resolution itself.
My daughter was in tribal court for 2 years. We were in there, and within that 2 years I was able to know that Claire was safe. And you know, one of the priorities of tribal court is to put him with family or someone in the community, so that but also gave me time to get balanced and back where I'm, so I could be a proper parent for my daughter.
Just as tribal governments have a great deal of flexibility in the way they structure their courts, they also have a broad range of options for operating procedures as long as they adhere to the principles of due process. This flexibility allows tribes to operate less formal courts, where people can state their case, judges and parties can freely question, and all the issues concerning the case can be talked over. The court can focus not only on what happened, but also on underlying issues. Cases begin with a petition being filed with the tribal court clerk.
So I went to my sister's house last night around 11:30 and she wasn't there. The kids were home alone. And I'm really worried about her drinking and whether or not these kids are being taken care of right.
Would you like to fill out a petition?
Yes, I think it's time. Yes, I think it's time that somebody did that.
Well, here is the petition, and you just fill out the children's names and their birth dates, and you write your concerns.
The tribal court clerks have essential roles in the day-to-day operation and management of tribal courts. Much of the work to keep the tribal court going forward falls on their shoulders.
The primary role as a tribal court clerk, you would send notification to all the parties involved. You would set the calendar dates for court hearings. You would do the filing, the mailing, all the correspondence, all the telephone calls, everything that's associated with the case, anything to do with tribal court. And then I have any questions that come up from any parties or any clients, I would notify the judges. I'm not a decision-making person. I can't make any decisions. All I do is take the information, contact my judges. They're the ones that come up with the decision, and then notify the parties or the clients or agencies, whoever may be involved in any case. Good morning, Minto Tribal Court. I would notify you by phone or mail of the next court hearing if they schedule you in for that.
Forms help to keep court systems running smoothly, consistently, and are important for communicating with parties, other courts, and with agencies. Some of the most important forms are petitions, statement of mailing or personal service, various types of orders, and notice of hearings. Notification of parties is a core requirement of due process.
Please connect the father by telephone now.
The father is online.
Yes.
This is the It's a Village Tribal Court, and today is June 8th. The time is 2 p.m., and we are here today to hear the case number 0512 in the matter of the children Rachel Smith, date of birth 6/3/98.
Tape recording the hearing provides an accurate record of what took place in the court proceeding. An alternative is to have someone take thorough notes of the hearing. The record of the hearing is important to all parties if a case should later be appealed.
The judges before you today were chosen for this case because we do not have any conflict of interest with this case. We ask that everyone be truthful. This is a child's proceeding. It is confidential, and what
Another
happens in the
requirement of
courtroom
due process is that the parties have a right to be heard, to tell their side of the story.
Yes.
The parties have certain rights in this courtroom. These include the right to be notified of all court hearings in this matter, the right to copies of any paperwork that is submitted to the court as evidence, and copies of all court-generated documents on the case, the right to the opportunity to be heard. If you have been properly notified and you choose not to come to the hearing, the court can make a judgment in your absence.
You know, the people that are sitting on tribal court have a big responsibility, not only to the tribal court, but also to their community, to their village. And I've been asked that question before about people that sit on tribal court. What I see happen a lot of times is that the person serve because they love their people.
Let's hear from the petitioner, the children's Aunt Lynette, first.
Well, like I said in the petition, I picked up the kids from Bonnie's. She was drinking somewhere. I sent my husband out to look for her, and he found her at our cousin's. They were drinking. We decided that we had helped her out too many times, and it wasn't fair for the kids to be living in this kind of environment. They call me all the time and come over to my house when there's partying going on at their house. There are some days where she won't even miss them. She won't notice maybe until a few days later that they're even gone. Bonnie really needs help sobering up, and if she wants to keep raising these kids.
Tribal judges make their decisions by considering all they have heard and evidence presented and applying tribal law.
Do the judges have any more questions for Lynette?
No.
George, do you have any questions for Lynette?
I used to send diapers for the kids, right, Lynette?
That was years ago now, George.
Anything else, George?
No.
They may also use state or federal law as guidelines. If the case is a children's case, judges generally base their decision on what is in the best interest of the children.
If we have problems with parents that we have to deal with their kids, we do it right here. We get foster care for them here. They don't have to go to Fairbanks, live with strangers. They're right here in the village. And I think that's the most important thing of the whole tribal court system. And we all know each other, we deal with each other in the best way that we can, or we know how. And our kids is very important to us. I don't think anybody want to see their kids go to another community or another city and be cared for by strangers.
I seen the tribal court help out a lot of families, and not only in Minto, but a lot of other villages called Minto and wanted to have their case taken care of in Minto, and we did a lot of cases from different villages through the telephone. And I thought that was great, helping others. I knew that working with people that do things wrong need help for themselves too. And I always step in when I think I need it to. I'm not educated, but I'm educated in our native way.
Court will help your kids to be right at home. That's what we're working towards, for them to be with us, not away from us.
It's really strong thing, the tribal court. We didn't know what we were missing when we were down here in the old Minto. We didn't know there was that much rules, laws, we didn't know. But we learn after you have to get old before you learn everything.
The circle is a universal symbol for unity and wholeness. It is a central theme and Native American wisdom. The circle is being used for a very different style of deciding sentences. People sit as equals and take turns talking about a case. They then decide through consensus what the consequences will be. A variety of terms are used to describe these circles, including justice circles, circle peacemaking, and circle sentencing.
We're going to talk about how we feel about a situation or what we saw in terms of this situation.
The procedures for circle hearings are very simple. Basically, a feather or other symbolic object is passed around the circle, and people speak while they hold it, and listen while others are speaking. In the first rounds, each person talks about the situation from their point of view, expressing feelings and concerns they have. After these things are thoroughly discussed, the discussion turns to what the sentence or consequence should be.
We settled down that morning, 4:30 in the morning.
The leader sets a tone of healing and problem solving and assists by opening and closing the circle, which may be done with prayer or words from an elder. The leader guides the circle through the process of discussion and reaching agreement, summarizing the main points that are spoken and decisions that are made, making sure consensus has been reached. The rules of the circle are quite simple.
Respect one another. That's the number one rule of the circle. And so that means no abusive language or yelling or being very harsh with your words. Okay, words are very, very powerful, and we can hurt each other with our words. And the circle, the intention is for healing. The main number one rule is respect. The other rule of the circle is that you only speak when you have this feather. I also want to ask people to make a promise, and if you would, just go ahead and raise your right hand. And what we're going to promise is that what is said in this circle stays in this circle. The words here are safe, and what is we said here stays in this circle. And also to promise that we will work together to come up with a good solution for what the consequences should be for this situation. So do you all promise?
Justice circles ask offenders to be accountable for their actions, encourage responsible behavior and choices, and aim to build self-esteem. Sentences are designed to promote wellness and strengthen the village as a whole. This approach is called restorative justice.
Talking with your elders will help. And the 100 hours of community's work service, especially working for the elders, would help a lot. I agree with reading the driver's manual and also agree with not driving the four-wheeler for a few weeks or a few months.
Tribal courts have a wide range of options for creating sentences. Community service may build on the offender's strengths and interests and create opportunities for them to practice and learn traditions and new skills. Community service that helps elders, people in need, or the village as a whole builds pride in both offenders and the village. Tribal courts may order a wrongdoer to apologize to victims in writing, orally, or to the whole village at a community gathering. Restitution, or repairing damages, has played a major role in tribal justice systems for generations. Counseling by professionals, elders, or peers may be helpful. People may be ordered to complete specific programs to deal with underlying problems.
The connection between culture and tribal courts has to happen. I mean, if you have tribal courts separate from the way we handle our affairs culturally, then they're not going to have the relevance there in a local community and will not be accepted as a part of the dispute resolution mechanisms that communities have traditionally used for hundreds of years. So we're going to have to marry culture with the way our modern tribal courts are operating, because without that, we're not going to have the validity in that governing institution that all governing institutions that impose things upon people's lives need in order for it to be enforced. Because one of the problems we have is we have so little enforcement. Any decision or any resolution that a tribal court brings out in a village situation has to be with minimal enforcement, and it has to be commonly accepted not only among the victim and the perpetrator, but the whole community as well, because everybody is watching what's going on. So we have to bring the culture into it, and the way we've been doing it here is by bringing the elders together with the youth, as well as the tribal leadership, who might be in their 20s up to their middle age, to the middle-age group, and really getting everybody across the spectrum involved. So you've got the elders providing that presence that, yes, they're going to be watching us and making sure that cultural standards and cultural protocol are adhered to, and that it's really just the way we do business.
Tribal courts, with their understanding of traditional values and cultural practices, give Alaska Natives the opportunity to care for their communities in a healthy, healing way.
Ni